welcome back, everyone. More and more people joining after the lunch break. Really happy to be back here on this deep tech stage with AIS. Great to have you back, Siim.
Hi.
Lovely to chat again. Axel, pleasure to meet you.
Yeah, pleasure on my side.
Great to have you both here. And this afternoon, I want to talk a little bit about IP, about knowledge transfer. There's many different things about AI. A bunch of questions that I have for both of you and want to dig a little bit into that. I think it's topics that are incredibly relevant in the, let's say, the light of what's been happening in the last 12 months in startup land and in the development of AI in general. And some pretty, I would say, tough questions for you guys. So I'm very curious to see your take. I will be honest right from the get-go. As the talk is a lot about sort of intellectual property, but then also AI and intelligent, let's say, algorithms, a bunch of my questions have been prepped or created together with AI. So some of those words you will see in the way they're worded are with a little bit of help from ChatGPT.
But are those questions original, though?
Well, that's something that you can find out in a second. So before we start, quick introduction from both of you: who you are, what do you work on day to day, and sort of why you're on stage today.
Age before beauty, perhaps.
Okay, Axel Stellbring, I'm a patent attorney for over 30 years. We give advice to many startups here in Estonia. We are very proud of this. Among the most well-known is Starship, for example, Ready Player Me, and there are many others, Pactum, etc., etc. So we have dozens of Estonian startups. Why is an interesting question. Why Estonia? I think it is because we have the Alan Martinsson is really helpful in making us known in Estonia. And is heavy software and AI. So this is needed here and is being applied very nicely.
Great.
Hi, so I'm Siim Kinas. I'm the head of technology transfer and IP at Enterprise Estonia, and I help companies to basically make their knowledge make money and make the knowledge move between companies, so it could actually create even more value.
Brilliant. All right, so let's dive into it now that I know a little bit more and that the audience knows a little bit more about who you are. What challenges do you see now in 2024 that startups face with patenting AI innovations when those systems can also sort of learn and develop like further technologies?
That's an easy one.
Now, Siim, your turf first.
Oh my God, where do we want to start? So basically, I would say that the AI and especially the appearance of ChatGPT 4 last year sort of really messed up the table. So by that time, it sort of looked linear progression about what's going to happen. We could sort of see there was legal clarity about what's going on. Now all of that is out of the window. So now we have basically co-creation of let's say creative works co-creation between machines and humans. Then we have who's actually the owner of the IP generated by a machine. Then we have the application of the machine inside different systems. What's going to happen then? Who owns what? So it's a mess. It's a really exciting times. We have the AI Act coming out from the European Parliament. We have similar activities going on in China, in the US. So it's a very active and developing area. So when internet came a big thing, then there was this sort of thought that maybe internet would be the thing that would sort of break copyright. And sort of now I think we're at another door to see whether or not AI may be able to break copyright and IP as such, because sort of such a difficult and interesting area.
Yeah, Siim, that was a perfect generic comment. I go a bit more into patent law, which is my business, right? So there is a lot of prior art. So you know that one of the hurdles in patent law is to be novel and inventive. Okay, this is an old story actually, but there is a lot already as prior art out there. So if now a startup decides, hey, let's implement AI now for the first time in an application, it's not as easy as it used to be 5 years ago when people were fascinated just by the name or word or abbreviation AI. Now you have to fill it with content. You have to really disclose what exactly are you doing. And my most important message for the day, and I know that Estonians are pretty talented in this, much more than Germans, by the way. They are very focused, much better than many startups, as I said, in Germany. And it's very important to then protect the product you are handing over to the customer. Not the training process can be protected, but the more important issue is to also have the final product being protected, because this is the cash cow. This is the one where you want to generate income by license royalty or have a monopoly. So I've already left my most important message up front here.
Good.
Maybe just to even build upon that, you said sort of the prior art is an issue, and it's a horrendous issue because just last year they filed over 100,000 patent applications to do with machine learning and AI. So not about AI itself, but the application of AI. Be it medical applications, be it marketing, be it communications, wherever, AI is coming everywhere. So it's also dragging with it our areas of development of the industry that were stagnant for decades. So for example, with let's take the example of recycling. Used to be done only by people, like going on a line, picking up stuff that they recognized, everything else went into the incinerator. Now we see in patent data that AI is dragging recycling in, technology with them, because now we have AI who can actually determine what kind of plastic this is, where should it go. So not only are we going to stuff like AI and IT, it's having real world effects in industries that don't even know yet that they're affected.
That makes a ton of sense, actually. You're talking about specific industries. I kind of wanted to dig into one that I think has been, with a lot of startups that I've been discussing to as well, that are working in sort of more arts and music industry and sort of industries that are not so directly linked to deep tech. For like AI-generated content, like in music, text art, like how should you, how should current like intellectual property laws be like adapted in some way, or where do you see that being adapted in order to protect that AI-generated content?
Yes, I'm a patent specialist. I'm not so much a specialist in copyright. Nevertheless, one of the crucial, and Siim has already touched this topic, is of course, hey, who is the composer or the proprietor of what has been generated? But from patent law, now I take my discipline as a starting point for the discussion. In patent law, there have been worldwide proceedings because there has an invention been made by AI only. So they coded something that the invention was generated only by AI. And then they designated as an inventor and applicant this AI software. And there was an interesting question. In Australia, they were pretty liberal. They allowed AI to be a proprietor of something, while the rest of the world said, hey, no, because it's a principle, it's always a human being behind. I think it will go into that direction, otherwise it will be too complicated. Just one little side story, how far this can go. So I've heard from the head of the Ethics Commission in Germany that the German automotive industry is of course smart enough to think, hey, what do we do in case of liability if AI is driving this car into a crowd of people and they want to make us liable? And so they wanted to create a new personality, the I personality, into our constitution. Of course, we started laughing about it, but you see, it's a crucial question. Here it is the question of liability, not who is the creator of a nice piece of music or piece of art. So I think it will stay as it is, not only for conservative reasons, but it would kind of break the whole principles, I think, of honoring people for what they have created. And here is also in the causal chain at the beginning somebody who has coded this whole thing or collected the data, etc. But I'm curious, Siim, what your opinion is in that respect.
Yeah, it's really difficult to actually have a position at the moment. I'm of the feeling that I think AI is going to have agency. It's going to be an operator. An instance of AI might be liable for things in the future. It seems to me. Otherwise, we see that the difference between a legal person or a physical person and an artificial person are becoming more and more nebulous. So you can't actually draw a line in there. So I think that we as a society as a whole are going to have to deal with that question at some point. So So wait and see. Let's see.
I kind of wanted to, it's super interesting. I actually had a question later on about like liability, which you're already touching upon, and whether we're then sort of putting that responsibility on the AI developers, on the users of like the AI, or on sort of the AI itself, especially when it comes to like self-learning, like, and who is end up, you know, responsible for these things. I think we're talking about autonomous vehicle, which is one of the first one where that comes to mind. But there's many other things. As factories become completely automated, then that question comes again, right? I just saw an article a couple of days ago that was showing that the amount of AI robots that Amazon uses in these warehouses has more than doubled over the last couple of years, going now to 750, you know, million robots that are like just going around, moving things. So those questions basically come up, but talking a little bit more maybe sort of on the data side, right? So IP and sort of general intellectual property protection for startups very much is linked to data. Like, so when it comes to that data ownership, you know, what rights do individuals have when like AI starts to train over like their data? And like data that's been produced by certain individuals, and then the AI model takes that and builds on top of this.
Shall I start this? Okay.
Please do, yeah.
First thought on this question. It's a difficult question, by the way. It's pretty challenging, right? So it's one of the iron principles in copyright. Whoever is the creator has the rights also to copy and make use of your creation. In copyright nowadays, you can also protect data, by the way. If you are collecting even data of others, the collection per se is your in your possession. You are the master of this very collection. And if somebody wants to make use of this collection, they have to ask you, and they can't even copy this. I think at the very end is an easy answer. It is always the creator of the data who has full rights if it's being used commercially. This is always the restriction. In private use is an entirely different story. But for commercial purposes, it's always the people who have invested time and money to either generate the data, there is this generated data, or the assembled data. Both is being protected by copyright law. So that's, I think, a clear-cut question for the time being. Zim, any concerns?
Yeah, so I totally agree with you. So the only question there is, of course, in the European space, we put a really big stress on the rights of the private person. So whether or not they are actually agreeing to the personal data being somewhere in a database. So that's something that we need to look into as well, because in the advent of AI, we're looking at big data. So it might very well be that all of the information about what our activities is behind some wall, some privacy wall, but we all leave breadcrumbs all around the internet, for example. So I might create an AI to collect all those breadcrumbs and still build a picture of you. So then we even then push the privacy barrier even further and make even more data private until every information is private, and that also doesn't seem to be like the solution. So AI, again, impinging on another thing, like the privacy laws. So yeah, let's see what's going to happen with that.
One other comment or idea that is striking my mind. So there's a German camera manufacturer who, being the first camera manufacturer in the world, they are creating pictures and they are authenticated. So it's a true picture. They stamp the picture in electronical manner, so it is clear who is the originator and it's not manipulated. So probably we have some days similar principles apply to other things we are generating. There will be an individual stamp or ID code, or I don't know, so that also these breadcrumbs, I like this picture you have given, Azim, the breadcrumbs can be identified if it's kind of considerable breadcrumbs, not any breadcrumbs, but then you know who is the originator, and of course it makes it complicated, but it may be automated also. I'm thinking of our client Pactum, by the way. They are doing negotiations of contracts in an automated manner, so it can also be even automated, this authorization for these individual breadcrumb authorization. Would be a nice name for a startup, I hope.
So actually, you touched on a really important point there. So we are talking about all of those really cool things, very rational things about like business and IP and stuff like that. But I had this really good quote from will.i.am, the musician, recently, that we are investing billions into AI, but pretty much nothing into HI, like human intelligence, which is a real problem there. So we are losing the human, and I think the discussion around AI is actually forcing the discussion about the humanity and why are we here then? into the forefront. So, I'm guessing you're talking about Leica. Yeah. Okay. So we have a similar action coming from Nikon, for example, from Japan, who have taken like a public campaign. We are there for the real picture. So the picture as you, as a human, as a creator that you made. AI is nice, but we are here with real picture. So that discussion is something that is also going on, like in parallel around the AI discussion.
So moving maybe a little bit away from like AI directly, but more sort of on the patents, IP in general, and sort of legislation. You mentioned that when some of those questions come up, certain countries, certain governments kind of step forward and say, oh, we're going to try this, or we're going to be in the forefront of this. I'm thinking of Estonia with the way that the government services are digitalized in an incredible fashion, but I think to the eyes of many other countries, that might have seemed crazy when that started and when that development was kind of like kicked off. How do we sort of go about on an international scale to like harmonize that, from like an intellectual property perspective, but then also the way that the AI development is like portrayed forwards? How do we start harmonizing laws, like whether maybe in the EU first or like globally, so that it doesn't start to come with outliers where those are being created?
So you've looked at me, right? So interesting, very interesting, challenging questions you're asking actually. So anyhow. Strange enough, the European Patent Office has been the most liberal authority worldwide to allow software. Now I start talking about software, then we come to AI, which is also software, to allow software to be patented. The Americans, for some, it was a pendulum by the Obama government because they were so afraid of the non-practicing entities challenging others, the trolls, the so-called trolls, and so they were. All of a sudden, they were very restrictive. They call it abstract subject matter. Okay, EU or European Patent Office. I have a friend there in the Board of Appeal, and he says, I come from development. I'm a software engineer, and I want my work protected. And of course, now I see all these inventors, and they should get the same protection as others. So the European Patent Office has been pretty liberal. Now the Americans follow again. They have swung back a little bit, I would say. So from the extreme, it has gone a bit more to normal, and the US PTO is now trying to copy the European aspect. Now, AI. This was software only, and software can be patented. By the way, everybody listening to us, this is one of the things I am spreading around in Estonia. If there is any kind of technicality, we probably have to address this one also. Technicality is one keyword here, but if there is any kind of technical application just good enough, you can patent it. Now AI. AI basically the same. So there is this common feeling of not feeling well. Actually, we have to address it, and now there are conferences and also attempts to harmonize among the patent offices. And you've seen already with the question on proprietorship, they have kind of found a conclusion now. It's absolutely clear for the time being AI can't possess an IP right, and also further now there should be some protection, but inventive step is here the double hurdle, so to speak. In view of the prior art and technicality, it needs to be technical, the difference, and then you are also, this feature of an invention is assessed in assessing patentability, so you have this kind of technical and inventive approach which has to be fulfilled. So this was sorry for being a bit...
No, that's great, it's very good.
Okay, so you covered the technical side, so I'm going to go with the legal side here. So the AI Act, accepted by the European Parliament in late December, it was already ready, almost, last year. So that, well, actually the year before that, because we're 2024 now, it was already ready to be accepted, and then ChatGPT-4 came and screwed everything up. So that was like a capabilities that had not been seen from an AI before. No one thought it was possible. So hence it took another year. By that time, the Chinese and the US, with their legal undertakings and regulations attempts, were already ahead. Until that time, EU was like the, amazingly enough, was like the spearhead. We're going to regulate AI and make like clarity in the legal space for AI companies of what's going to happen. So, yeah, regarding the question about harmonization, we'll see.
We'll see. Okay, that's great.
Always these cliffhangers here. See him.
Yeah, but I figured that it was a difficult one anyway, and that nobody would have the right answer. Just curious to kind of have your take as you work on that, day to day, and with lots of companies that are in that field, kind of where it's heading. As we need to wrap up now, just wanted to ask you like some pieces of advice for, let's say, founders in the audience, that are working in developing like deep tech, that are working in developing patentable, let's say IP protected like technology in general, that are thinking of like what's next for them. Like what are some key things that you want them to keep in mind?
Yeah, I have one advice, please take it serious, and it's not a question of a lot of money or number game, it's about quality. So one patent application, one patent of high quality is much, much more worth. There are lots of statistics behind which are fairly unknown. Okay, this one application is by far more valuable than hundreds of, typical patent applications where people try to save money, time, effort, etc. This is my best recommendation, and please also include the future prototypes in what you have at the moment in mind. It's not what the legislator expected us to do here, but of course, if you file a patent application now, it's already reflecting the past. It's not the present, okay, even. You have lost already some time here, and you should also give a reflection onto the future as long as it is doable. I mean, this is also a prerequisite. It should be doable or enablingly disclosed. This is the official term. But you should also implement, you should really collect enough substance into this application, and this is, please provide more effort than what is typically done, because also the costs at the very end, they're given costs, okay? Each and every patent after in each country will accrue like 30 to 100K costs anyhow, irrespective of the quality of the upfront investment. So please invest properly and carefully.
Couldn't agree more. The patent quality, but we also sort of course, then we need to talk to companies and what the patent quality means. But sort of keep in mind that the patent is not just a patent to have. It's not like a check mark. You have to have it protect your your unique value proposition, the thing that your clients want you for, that the thing that guarantees your quality to the customer. That's the thing that needs to be protected. So, irregardless of technology. With regard to AI, is that we see that AI itself being basically a data set and the treatment of that data set. So we see the rise of trade secrets in the protection and in the control of IP around that, but all around, like the application of AI still has a technical merit, so that's the area where patentings come in. But don't make the mistake of thinking that patents is the only protection that is out there for you as an IT company. Or you have trade secrets and all the other opportunities out there that you need to take into account as well.
Fantastic. Thank you so much for those insights. Thanks for your answers, for giving us a glimpse of what you work with every day and kind of the kind of companies that you're helping. Thank you so much, Alex. Thank you, Steve.
Thank you. Thank you.